Good morning, everyone, and welcome to this HPMA webinar on investigating allegations of sexual misconduct in the workplace. So my name is David Major, and I'm a founder and director of Ibex Gale. I worked as an employment lawyer for around about 10 years before setting up Ibex Gale with my co-founder Poppy Jenkins in 2013. And since that time, I've personally conducted well over 100 workplace investigations of various types, many of which have been for the NHS and healthcare organisations. Let me tell you just very quickly a bit about Ibex Gale. We're a consultancy business which works predominantly in the NHS and UK healthcare sector, and we've worked with over 80 NHS organisations across the UK. We support organisations across a range of areas related to people management, organisational transformation and governance. And our biggest area of work is workplace investigations. We've got a team of around about 40 highly accomplished investigators with backgrounds in employment law and people management, all of whom have accumulated years of hands-on experience of conducting investigations. And we undertake in the region of 200 investigations each year, the majority of which are highly complex and require handling with the utmost care and sensitivity. And we've got particular expertise and experience in conducting investigations into allegations of sexual misconduct in the workplace. And that's the topic we're going to be exploring for the next hour. And the reason we've chosen that topic is because we've seen an upward trend in the number of complaints of sexual misconduct that we're being asked to investigate for our NHS clients in particular. And that would seem to reflect some of the attention that this issue has been receiving recently in both the mainstream and social media and from healthcare regulatories and representative bodies. So more on that in a moment. But first of all, here are the key things that we'll cover during the session. And just while you're looking at that, I just want you to note that we've been asked by the HPMA to record this session, so please note that we are currently recording. I would ask that everyone puts themselves on mute during the session, and we'll leave it to you to decide whether or not you want to have your camera on or off. The session is due to last around about an hour, and apologies in advance if we overshoot that slightly. To maintain the flow of the sessions, because we've got a lot to squeeze in, we would just ask that you don't ask questions during the presentation, but if you could instead type your questions into the chat as we go, then we'll try to address as many as we can in a Q&A at the end. And if anyone has a question they want to discuss with us confidentially, then please do get in touch after the session and we'd be happy to arrange a time to speak. We'll be sharing the slides on screen, and we'll also make a PDF version available in the chat after the session so that you can access it. So without further ado, let me hand over to my colleague Zoe, who is going to talk a bit about the current climate around sexual misconduct in the workplace and introduce herself as well. Zoe.
Hi, thanks, Dave. My name is Zoe Wood. I'm an Associate Director working for Ibex Gale. My background is employee relations. I worked in the NHS for over 10 years, most recently as Head of Employee Relations and a large I've been involved in doing it in reality and overseeing it within the NHS, as well as conducting and supervising them with Ibex Gale. So first of all, quick quiz. We're not going to do this in an interactive way. There are far too many people to do that. But I just want to whiz through a few sort of facts and figures just to look at the context and the climate, as David mentioned. So in 2021, there was a BMA report. What percentage of women doctors do we think had experienced sexism in the workplace? There's a surprising 91% of people reported experiencing sexism in the workplace. What percentage of women in the report said they've been treated less favourably because of their gender? 47%. And then how many said they'd experienced unwanted physical conduct within the workplace? That was 31%. And the Royal College of Surgeons stated a percentage of female surgeons that had reported harassment and sexist abuse. And that's 50%. And we'll talk a little bit more in a minute about the European Human Rights Commission, but they conducted a survey in 2018, and around half of respondents in that survey hadn't reported their experiences of harassment to anyone in the workplace. And the barriers that they reported included the view that the employer wouldn't take the issue seriously, a belief that the alleged harassers, particularly senior staff, would be protected. They reported a fear of victimisation and a lack of appropriate reporting procedures. Sorry, I'm trying to move forward my slide and it's gone to sleep. There we go. NHS staff survey. I'm sure all of you will be really familiar with the NHS staff survey. And it's interesting looking at this. So 2023, the NHS staff survey reported that 9% of people had personally experienced discrimination at work, and that's in the last 12 months. So that's quite a significant figure when you look at it in that context. But what the staff survey doesn't currently do is differentiate between different types of discrimination. So that could be race discrimination, disability discrimination, sexual harassment. This figure has increased year on year, and I think we're seeing, as David said, that upward trend in a lot of the cases now being reported and investigated. And then I'm sure lots of you will also be familiar with this. So there's been lots and lots of articles in the press around what the media are reporting as the Me Too moment for the NHS, and there's been lots of headlines. Just a couple of days ago, there was a headline in The Guardian saying that hospitals in England are underreporting sexual misconduct. And on the 23rd of May, the BMJ published an article saying that medical colleagues and healthcare unions have urged the government to take immediate action against sexual assault and harassment in the NHS after this investigation that was conducted by the BMA. And The Guardian found that trusts are failing to protect staff and patients. Now, it's worth noting that that's wider than just sexual harassment in the workplace between colleagues, and that those incidents also involve patients abusing staff or other patients. But there is a significant concern and proportion of those which are the staff-on-staff issues that we're exploring today. And also surviving in scrubs. I'm sure a lot of you will be familiar with this. If you're not, it's really worth looking at and a bit of a read through some of the accounts. So it was a campaign that was launched to give a voice to people in healthcare, to raise awareness and end sexism, sexual harassment and sexual assault in healthcare. And the co-founders are Dr. Becky Cox, who's a GP specialist, and Dr. Chelsea Jewett, who's an emergency medicine trainee, launched this in July 2022. And it's a space where people can submit their stories anonymously, and then they're published on the website to create this shared narrative of experiences to hopefully push for change within the healthcare setting.
Thanks, Zoe. I'm sure many of you, all of you probably will be familiar with the GMC guide, Good Medical Practice. It's the guidance that's issued by the GMC, which describes what it means essentially to be a good doctor, ethical guidance for doctors. It's currently very light on detail around sexual misconduct and discrimination more generally, but changes to that are due. So the GMC undertook a period of consultation, public consultation from April to July last year to consult about proposed updates to good medical practice. The changes are proposed to affect four main areas, one of which is tackling discrimination and promoting fairness and inclusion. And it's proposed that there will be a new duty not to abuse, discriminate against, bully, exploit, or harass anyone or condone such behaviour by others. And they're also proposing to strengthen their guidance around inappropriate sexual behaviour between colleagues. Worth noting as well, the NMC code, again, currently very light on detail around sexual harassment. There's only a duty currently to treat people fairly and without discrimination, bullying, or harassment. We wanted to highlight some other useful guidance around the issue of sexual misconduct in the workplace. The Equality and Human Rights Commission, the EHRC, has produced some really helpful technical guidance on sexual harassment and harassment at work more generally, which is really well worth the read. It deals in quite a lot of detail with some really key issues around sexual harassment. Section 5 of the guidance in particular deals with addressing allegations of sexual harassment formally, and there's some really good guidance on how to go about your investigation and some key things to keep in mind when you're investigating. The ACAS guide to conducting workplace investigations, not specific to sexual harassment or misconduct, more generalized, but some really, really good detailed guidance there on how to go about conducting your investigation, and particularly some of the later sections on how to formulate findings and conclusions and assess evidence, which we'll look at later in this session. And we wanted to mention as well the case of Sellers and the British Council. Now, this was an employment tribunal judgment from December 2021. So it's only an employment tribunal case. It's not a binding authority, but we thought it was a really good example of where things can go wrong when you're investigating and addressing an allegation of sexual misconduct in the workplace. We'll make specific reference to aspects of this case during today's session, but just in brief to give you an understanding of what it's about. Mr. Sellers was country director for the British Council in Italy. He held a Christmas brunch at his apartment, which was attended by the complainant, a female employee of the British Embassy in Italy. And shortly after the party, she submitted a complaint to the British Council, alleging that Mr. Sellers, when saying goodbye to her at the end of the party, had kissed her on the lips and run his hands over her chest. The British Council conducted an investigation. They held a disciplinary hearing, and he was dismissed. He appealed, and he lost his appeal, and he submitted a complaint to the Employment Tribunal. And he won his case due in a large part to the tribunal finding that the British Council's investigation had been seriously deficient in a number of respects. We'll highlight some of those deficiencies during today's session, but well worth reading the full judgment, and we've got the link there in the slides. So we'd encourage you to read at least all the guidance that we've highlighted here before starting any investigation into sexual misconduct. Worth noting as well that maintaining high professional standards in the NHS, MHPS as it's more commonly known, will also be relevant if you're dealing with a complaint against a doctor or a dentist. The focus of today's session is sexual misconduct in the workplace. The reality is, in most cases, you will be dealing with a complaint of sexual harassment. So let's just take a moment to remind ourselves of the basic legal concept of sexual harassment. And just to be really clear, during this session, we're going to use the terminology the complainant to refer to the person making the allegation and the respondent to refer to the alleged perpetrator. So we've got there on the slide the legal definition of the basic legal definition of sexual harassment. There's more to it than that, but that's the basic position. So we're talking about unwanted conduct of a sexual nature which has the purpose or effect of violating the complainant's dignity or creating an intimidating, hostile, degrading, humiliating, or offensive environment for them. So in our experience, it's not that common to deal with a situation where there is clear evidence that someone behaved in a certain way with the purpose of creating that environment for someone. It's more often the case that you'll be having to consider whether the way that someone behaved had the effect of creating that environment for the complainant. And so when you're considering the effect of unwanted conduct, really important to be clear about what factors you take into account. The first thing is the complainant's perception. So there is a subjective element to that, complainant's perception of the conduct. Other circumstances of the case, so might be the personal circumstances of the claimant, perhaps a health condition or vulnerability, or perhaps of the respondent. You need to consider whether or not the respondent perhaps is in a position of trust, power, or seniority, or there might be factors relating to culture or religion. So important to look at all the circumstances of the case. And then importantly, there is an objective element to that test. So whether it's reasonable for the conduct to have the effect that the complainant is saying it had. And it's important to remember that aspect because you may well come across cases where it appears that the claimant might have misinterpreted conduct, or perhaps is being unreasonably sensitive or has been unreasonably sensitive to particular types of conduct. And in fact, there was a recent case in the press over the last week or so, the case of Garina Gasparova, an employment tribunal case, which was a really good example of an example of a case where someone had interpreted innocuous work-related incidents with her boss as having sinister sexual motives. For example, he'd run his hands through his hair and looked at her at the same time, and she'd interpreted that as him trying to chat her up. He'd use X's in emails to indicate where he wanted further information from her, and she'd interpreted that as him putting kisses in the email. So an example where the tribunal found that the complainant had been hypersensitive and had misinterpreted essentially innocuous conduct. And just to be really clear, sexual interaction that's invited, mutual or consensual is not sexual harassment because it's not unwanted. But sexual conduct that has been welcomed in the past can clearly become unwanted. Okay, now let's look briefly at setting up your investigation. So an allegation comes in of sexual misconduct, sexual harassment. What do you do? Well, allegations could come in a variety of ways. Let's not forget that. It might be a verbal complaint. It might be via a formal grievance. It could come directly from the victim, or it could come from someone else who's raising it on their behalf. And it might come down a freedom to speak up route, or a dignity at work route, or a whistleblowing route. So you'll need to decide right at the outset on which process you're going to follow, which policy you'll adopt here in investigating these issues, and which policies and procedures might be relevant to the allegation in terms of providing guidance on conduct, for example. So you'll need to think carefully about that. And you'll need to put in place some really clear, comprehensive terms of reference, which set out really clearly, at the very least, the nature of the allegation that you're going to be investigating. You'll need to think about who would be the most appropriate person to conduct the investigation. The EHRC guidance says that you should think about the level of expertise and experience needed for the investigation. And bear in mind that the ACAS guidance on investigation says that the more serious the allegation, the more thorough the level of investigation that's going to be required. And in sexual misconduct cases, there may well be someone's career and professional reputation on the line. So think about whether the investigator have the right level of training and experience. If you're asked to investigate, think about whether you have the right level of expertise and experience. You might want to think about as well, in a case where the complainant is a female, particularly in cases where the complainant appears to have been particularly traumatized or is particularly distressed, you might want to think about whether it would be more appropriate to have a female investigator, given the sensitivity of the issues that are likely to need to be explored. What should you tell the respondent about the allegation? Well, in basic terms, the respondent should be given sufficient detail about the allegations to be able to respond and to put their case, perhaps their defence across. So you'll need to have a really clear idea, the respondent will need to have a really clear idea about the who, the when, the where, the how. Think about whether there are particular items of evidence that you might need to provide the respondent with up front. So if it's alleged that comments made in emails or messages have formed sexual harassment, then you might need to provide them with copies of those messages or emails so that they're really clear about what's being alleged. What do you do if the complainant raises a complaint but then doesn't want you to investigate? And there might be many reasons why they may be reluctant to get involved in an investigation. Well, Very simply, you might need to investigate anyway, even if it's against their wishes. And the EHRC guidance says that you should consider why they don't want an investigation and how serious the allegation is. Consider whether you can provide the complainant with reassurance, perhaps, on the issues that they're concerned about. If they're concerned about repercussions, can you provide them with some form of protection? Where possible, respect the wishes of the complainant. Otherwise, you could compound the harm, but you need to balance the risk to the complainant versus the or against the wider risks that the alleged conduct might pose to others and to the reputation of the organization more generally. You might want to think about and perhaps should give consideration to suspending the respondent, but it should never be a knee-jerk reaction. It may not be necessary. You need to think about all sorts of factors, such as the seriousness of the allegations, the potential risk to the complainant and others, the risks of to the integrity of the investigation if the respondent stays at work. Consider alternatives to suspension, such as moving the respondent. Probably never going to be a great idea to move the complainant, because there is always going to be a risk of a complaint of victimization as a result of that. The EHRC guidance again says that you should set and communicate really clear target timescales for the completion of the investigation, and then update the parties regularly during the investigation. And you might also, in fact, you probably should consider putting in place support measures for the complainant and the respondent, because this is likely to be a really difficult process for them, and the complainant may have already been through a really difficult experience. So support is going to be really important for them. Okay, so one thing we really need to be investigating in it, particularly in cases of alleged sexual misconduct, is the possibility of police involvement, whether or not the allegation could potentially constitute a criminal offence, and whether the complainant has reported the allegation to the police or intends to do so. The issue here is the possibility that your investigation might prejudice any criminal investigation or prosecution that might come further down the line. If the allegation has already been reported to the police, find out what steps the police have taken. So get in touch with the police and find out what they're doing. Are they actively investigating? If so, what stage are they at with that? What are the timescales for that? Police investigations, in my experience, into these sorts of things can often go on for a really long period of time. If the allegation hasn't been reported to the police and the complainant doesn't intend to, should you, the employer, consider reporting it? It's got to be the claimant's decision in most cases. It should be, and you should, if you can, respect their wishes. But you might need to consider the possibility of wider risk or harm. That might be more likely, perhaps, in a case involving sexual misconduct towards a patient, because of the possibility it might have happened to others, and the wider risks that might pose to the public. Don't assume you can't take action just because there might be police involvement. Liaise with the police, ask them the questions, get something in writing if you can to confirm what they tell you. And ultimately, even if the police say you can proceed, you'll still need to think carefully about whether it's reasonable to do so, pending the outcome of any police investigation or trial. So the respondent, for example, and again, this is a situation we've come across, the respondent might have had legal advice to say, don't engage with the investigation because you'll prejudice your position in the court proceedings. Well, would it be fair on the respondent in those circumstances to proceed with an internal investigation if they're effectively given a legal advice not to engage? You'll need to think about that. And if you decide to wait for the outcome of a criminal investigation or perhaps criminal proceedings at a trial, remember, there's a difference in standard of proof here. Criminal court proceedings, the police, they're looking at beyond reasonable doubt. We're only talking about the balance of probability. So even if the police or CPS don't pursue it, or if there's an acquittal at trial, don't assume you can't proceed with your internal investigation after that. The respondent may be very resistant to you doing so because they may feel they've been vindicated, they've been cleared. but you'll still need to consider your duty to the complainant and the risks of not continuing or starting an internal investigation at that stage. Zoe.
Okay, so the issues of confidentiality and anonymity are always a factor within sexual harassment, sexual misconduct allegations and cases. It's really, really important, and what we want to do to make sure that we're protecting people and we're supporting people through these processes. So the EHRC says that you should warn witnesses that it's a disciplinary offence if confidentiality is breached. So just being very, very clear up front around what that confidentiality looks like. It's really important that you don't let it prevent you from interviewing relevant witnesses. And this is always a bit of a challenge in investigations, looking at what's reasonable and proportionate and considering, as David referred to earlier, the potential seriousness of these allegations and the impact that they might have. So thinking really, really carefully about who you might wish to speak to, using that very clear requirement around confidentiality to sort of manage and minimise the impact within the organisation. And in the Sellers case that David referred to previously, they decided not to interview certain people in order to maintain confidentiality and keep it quite tight. And this point was highlighted by the tribunal as a flaw in their investigation. And anonymity. We are often asked about anonymity in these cases. We've talked about it where somebody has raised an allegation but perhaps doesn't want to wish to take that through formally. There's also people that we might wish to speak to in the investigation and they may request anonymity. It should only be really agreed in exceptional circumstances because it causes a number of barriers to the investigation. So first and foremost, fairness to the respondent. The respondent needs to have full details of the allegations that are put against them, and it is likely that that will identify the individual. So promising anonymity in those circumstances is not really appropriate to do so. You might be satisfied in some cases that there are some good reasons for anonymity, but you do need to consider the impact that that will have on the respondent and on the robustness and the fairness of the investigation. You also need to be clear to individuals that whilst you might be able to offer some sort of anonymity if you have decided that that might be appropriate in your investigation, there may be future formal internal or external processes which may require the evidence to be presented in such a way that that anonymity is no longer possible. So, for example, if there are GMC proceedings or there are tribunal proceedings. There are also, as David referred to around the potential criminal matters, there are also potentially safeguarding matters. And if there are safeguarding issues, we would not be wishing to promise anonymity because there may need to be discussions with the safeguarding team or the local authority designated safeguarding officer. So I think the important point around anonymity is that it needs to be very clearly qualified, and the caveats, as I've just talked about, would need to be provided. But I think in most cases, what we want to be doing is really just exploring with the individual measures to reassure them, but also to protect them. And going back to that initial point around if somebody does breach confidentiality, that is potentially a disciplinary issue, and so action would need to be taken if that were the case. And then the next point in the investigation is just thinking about the importance of culture and context. So there's a much wider context in quite a lot of the cases that we've looked at. And so just being mindful and thinking about those. So thinking about things like whether there's a culture within the workplace where sexual banter, coarse language might be the norm, and also whether potentially there is any historic poor behaviours. That might be allegations, or it may be just other intelligence or information you can get from people. And this might relate to the alleged perpetrator, or it might be something more widely in that wider culture or context within a team or within a service. Sometimes that's because behaviours have been allowed to continue, and perhaps they are relatively low-level behaviours, and those things have not been called out and addressed, and it's become the norm. And sometimes new members of staff will come in and then they'll start to raise concerns and they'll start to raise issues. So just thinking about that culture and context. And then thinking about the complainant themselves. So have they been party to some sort of sexualised behaviours? So looking back to that culture and where banter and behaviour is sexual nature has been normalised, has the complainant be party to some of that? Because that might be a factor in your considerations. Have they potentially consented to the behaviours as alleged? And we've seen this, for example, in cases where some initial banter or flirting has sort of started out as something that people have felt comfortable with, and then has either changed course or has become something that has not become comfortable. And so what was originally consensual may have then gone beyond what somebody's comfortable with. And so just being mindful and getting to the bottom of those sorts of things can be quite tricky. And so the importance of investigating that carefully. And then also thinking about culture of power dynamics and the existence of power imbalances or inequality within the workplace. And we see this is really common in healthcare settings, particularly where you've got well-established consultants that perhaps treated quite deferentially. You've got staff who may be reluctant to speak up against them for fear of either reprisals or just because they're an authority figure and they're somebody that's really, really highly respected for their clinical capabilities and they have a really big reputation within the organisation, and people feel quite concerned to raise concerns in those situations. And has the alleged sexual misconduct occurred in the context of an intimate relationship? Relationships in the workplace are always really, really tricky, and we can't stop them, and there's nothing to stop those relationships from happening. But we do need to be clear and careful where there are such relationships, that firstly that's out in the open, that there are declarations around those relationships, and consideration then of any possible conflicts in terms of line management, and also just in safeguarding those people around perceived favouritism or potentially unfair treatment. Dealing with historic complaints. As per the previous slide, where there's potential culture or perhaps wider issues, sometimes some of the issues that we're asked to look at and investigate have happened quite a long time ago, but they might provide a bit of context to the issues that have been raised. And the EHRC guidance is clear on this, that employers should not set a time limit for sexual harassment allegations, because there could be all sorts of reasons why somebody feels that they're unable to raise the concerns at the time. Don't assume that just because an allegation is historic that you won't be able to investigate it, because you won't know until you try and you start trying to dig up some of that information. Having said that, they are really difficult to investigate, mainly because of the passage of time and the impact that this will have on people's recollections and the possible evidence that's available to you. So just some of the things to consider really when you're looking at historical complaints. So contemporaneous communication, so things that might have happened at the time, that might be WhatsApp messages, text messages between people, it might be other communications via email at work. It may be that the complainant perhaps spoke to somebody else about it at the time. They may not have formally reported the incident, but they may have spoken to a colleague or a friend outside of work. Documentary evidence, so other sort of information that might be relevant. So people might have made other sort of contemporaneous notes. They might have made a diary note about it. So just exploring whether there is anything that can help you support what might have occurred at the time. And then trying to nail down things like dates and times. And that's really difficult when you're asking somebody about something that happened in 2017. But just trying to be as thorough as you can to help them to have those recollections. So trying to help them link it to other events, shift patterns. Is there another way of trying to pull together that information to help you get a better idea of when something might have occurred? Because these are all the things that you're going to need to be able to put to the respondent in order to be fair to them, to be able to respond to the allegations. Consider speaking to former employees as well. It's possible that the key witnesses might have moved on, might have left the organisation. And I know quite often, we come up against this, the reluctance to speak to people that have left the organisation, and understandably so. But remember, there's a higher standard for investigation in sexual misconduct cases, and the Sellers case that we've already talked about is a good example of that. And so thinking about those risks and implications and considering whether there is relevant evidence from people outside of the organisation. And also think about previous track record. So there may have been a pattern of events over time, and they might be relevant. Now, it might be that there's not a list of formal concerns or complaints, but it may be that other people have experiences or have information that they can provide you with. So you try to explore them to the extent that it's possible. And then I think with historic complaints, you need to be open to the possibility that you might not be able to make a reliable finding. But ultimately, it's about trying to look to see what evidence you can get to support you making a finding on the balance of probability. And the key thing there is that you haven't made the assumption, but you've reached that conclusion through a reasonable level of investigation. In conducting witness interviews, these are normally highly sensitive situations, not only for the person that's raised the complaint, but also for the respondent and potentially for anybody else that's drawn into the investigation. So it's really important to consider the best way to conduct those interviews in terms of logistics for the people involved. So just be prepared to sort of think outside the box, really, and potentially adopt a different approach as to how you might normally do things. So face-to-face interviews is often preferred in these circumstances because it's much easier to build a rapport for somebody and put the person at ease if you sat in a room with them. But if it's face-to-face, just think about the location. So is bringing somebody into the workplace the right thing to do? So thinking about whether there's a neutral location that you could find to meet with somebody, because in the workplace, not only could you potentially trigger anxieties, but there could also be an issue of confidentiality if people see that people are going off to have these formal meetings. But remote meetings can often have the benefit not only of flexibility in terms of timings, but it also allows the person to have the meeting in their own private space. And we continue to conduct a lot of these things remotely because it does allow that flexibility. And quite often individuals, if given the choice, will opt for having that because they do feel more comfortable in their own private space. And also just think about holding the interview over multiple sessions. So where somebody might be particularly distressed or where there's a large amount of ground to cover, sometimes it's useful just to think about setting them up in bite-sized chunks to help that individual get through those sessions, because they can be difficult and they can be quite distressing for somebody to go over. And just think about going outside potential normal policy in terms of things like the right to be accompanied. So this should apply to the complainant and to the respondent. And if they're not a union member, they might feel uncomfortable with a work colleague supporting them in the meeting. So again, the EHRC says, consider other options like a friend accompanying somebody to the meeting in these circumstances, just to facilitate the meetings going ahead and to enable that person to feel as comfortable as possible in proceeding. And quite often what we will do is we'll have a short informal conversation with the person ahead of the interview. It's just helpful for them to meet you and to ask some questions about the process, and it can just put them at ease so that when you go ahead into the interview, they do feel a little bit more comfortable. And think about the order of the interviews that you're going to conduct. In most cases, you'll want to speak to the complainant first. That's fairly obvious because you want to understand the allegations in full. The EHRC says that the respondent should be interviewed at an early stage if possible. And whilst I can understand that it shouldn't be something that should be rushed into, it's really important to gather evidence from others to establish the facts before speaking to the respondent. So planning and thinking about that in advance is really, really important. And again, sometimes with the respondent, what we have done is if we're not able to meet with them immediately, we'll have that initial conversation with them just to put them at ease around the process. And then we will arrange a time to meet them that's most appropriate. And you'll hear this again and again in the session, but detail is of real importance in sexual misconduct cases when you're undertaking the interviews. It's often a case of one person's word against the other, and quite often there's a lack of corroborating evidence. And so you're having to make judgments about credibility based on really, really fine margins. So it's really important that you prepare very, very carefully for the interviews. We would normally prepare quite a detailed script of questions in advance, and make sure that we're in a position to share any relevant documents or other evidence with individuals in order to build up that full picture. If you're poorly prepared and you go in and you're blundering through the interview, then parties will pick up on that, and they'll pick up on that in terms of their confidence in your abilities, in your investigation, and in your ability to reach a fair and robust conclusions at the end of it. And no matter how detailed your interview is, it's going to be of limited value if you haven't got really, really good, comprehensive, accurate notes. So think about the best way to do that. So make sure you have a note taker, or if you're comfortable taking the notes yourself, that can be verbatim or near verbatim if possible. And if you're not confident about doing that, then consider an audio recording, ensuring that all parties agree in advance for you to do this. And just be aware of the sensitivity of the subject matter, particularly for the person making the allegation. Having to go through those events can be quite upsetting, and there's a risk that the complainant could be made to feel at fault when asking to give their account. And you read quite a lot of that, particularly a lot of the media articles talking about people feeling that they're made to feel at fault. So it's really important to go gently and be mindful of how it's going to make them feel when you're asking them to go through these things, and that they're not being cross-examined, but at the same time gathering the right level of detail is really, really essential to ensure that you're able to conduct a thorough investigation. The EHRC says it's not appropriate to ask a complainant of sexual harassment questions about their sexual history. However, I think that there might be times where some details might be relevant. So, for example, in the context of a previous sexual relationship with the respondent, you might need to understand the context of that, but just be very wary and careful about how and what you ask in those situations. Okay, over to Dave.
Thanks, Zoe. Yeah, and as Zoe said just now, the reality is in many cases of sexual misconduct in the workplace, there's likely to be a lack of strong corroborating evidence for either party's account. And the simple reason for that is that sexual harassment often takes place in situations involving two people behind closed doors. And in those cases, as Zoe's already touched on, detail is going to be exceptionally important, and you need to be going above and beyond the level of detail that you might think about obtaining in other types of investigation. What type of things might you want to think about when you are going about the process of collecting evidence? Well, first and foremost, you'll need to obtain really detailed accounts of the lead up to the incident itself, and the aftermath of the incident. Ideally, you're looking for a moment-by-moment timeline of events around the incident and the wider context as well, the wider circumstances. Be proactive in identifying witnesses. It's not the job of the parties to identify witnesses. You can certainly ask them for suggestions, but you need to be proactive as an investigator to, in terms of identifying all the people who might have witnessed something relevant, whether it's the incident itself, the before, or the aftermath. And interview people who you think might be able to provide useful information, unless there is a really good reason not to. And Zoe touched on the fact that in the seller's case, they failed to proactively identify other people who were at the party and who might have witnessed the incident, and therefore they missed out on potentially crucial evidence. So should you consider witnesses outside the organisation? Again, Zoe touched on this, and the answer is yes, you should, but you need to balance the potential value of their evidence against the wider need to maintain the confidentiality of the investigation for the sake of everyone concerned. And the same applies to other evidence. Don't rely on the witnesses to come up with the evidence. They may well be very proactive themselves in providing you with evidence, but you need to be proactive about that yourself, thinking about what evidence might be available. So much communication these days takes place on instant messaging apps like Facebook and WhatsApp and social media. And so you'll need to think about obtaining relevant copies of that, screenshots, perhaps from the parties. Establish the details around the scene of where the incident is alleged to have taken place. Think about getting a plan of the location, perhaps showing where the parties were, photographs of the location. Think about doing a site visit yourself. I've done that a number of times. It's incredibly helpful to get a sense of the location where things were alleged to have taken place. And again, in the Sellers case, British Council was criticised for a lack of clarity around where in the apartment the incident is alleged to have taken place and the sequence of events around the actual interaction itself. CCTV and audio and video recordings can be really, really helpful. So particularly where an incident takes place outside of work, at a social event, in a bar, a restaurant or a club. We dealt with a case recently where CCTV footage obtained from a bar where an act of sexual harassment was alleged to have taken place fundamentally undermine the claimant's account of what happened. And in another case we dealt with fairly recently, video footage taken by people on their phones on a night out, on a work social event, helped us to assess the behaviour of the respondent and the complainant and other people at the event. So incredibly helpful. You've got to explore things like that. Evidence from criminal proceedings. We talked earlier on about the potential for police involvement in criminal proceedings. And if you have to wait until criminal court proceedings have ended before commencing or restarting an investigation, perhaps, think about whether you can obtain evidence from that Crown Court trial. You might want to attend the trial yourself, to take notes or arrange for someone else to do so, to understand what evidence was being produced in the trial. You could try to obtain copies of the witness statements taken by the police, and they can be really useful when assessing the plausibility and credibility of people, because you can compare what they said to the police at the time with what they tell you possibly sometime after the events took place, and you can use that to assess the consistency of their accounts. Okay, so you've conducted your investigation and you've gathered the evidence, and now you come to the stage where you've got to assess the evidence that you've collected and make your findings of fact and reach conclusions in your investigation report. Just remember the balance of probabilities test. You're trying to understand, if you can, what is more likely than not to have happened. Ultimately, that's the test that you're going to apply. Your job as an investigator will be much more straightforward if you have direct witnesses to whatever is being alleged, or there's some sort of clear documentary or other evidence which points one way or the other. But in those cases where there are no direct witnesses or there's no other clear corroborating evidence, the plausibility and credibility of the complainant and the respondent may well be absolutely vital in terms of things that you're going to need to consider. So let's just look at what we mean when we talk about plausibility and credibility. Well, dictionary definition of plausibility: the quality of seeming reasonable or probable. So the question you can ask yourself there is there anything to suggest that this person's account is not reasonable or probable? For example, is it contradicted by the accounts of third parties or some other evidence? Does their account seem implausible or improbable in the circumstances for some other reason? Credibility, dictionary definition: the quality of being believed or trusted. And question there is there anything to indicate that this person's account is not worthy of trust or belief? Again, for example, has the person given inconsistent accounts, either in terms of what they've said has happened or the level of detail that they provide? So if someone has a poor recollection of events generally, but can provide a lot of detail in particular in relation to a particular aspect of an event, or vice versa, that would be a real red flag for me around the trustworthiness of their account, because it suggests an inconsistency in terms of their ability to recollect. Is there any aspect of their account which can be proven to be dishonest against objective evidence, which might suggest that their account can't be trusted or believed more generally? things that you might want to consider when assessing evidence and the plausibility and credibility of people's accounts. And these are just a few examples. The complainant's reaction. Let's bear in mind the fight, flight, freeze response. So you'll need to assess whether the complainant's reaction to whatever happened seems credible. Be mindful that people respond in different ways to traumatic events. The freeze reflex, try to carry on as normal and don't react. So they don't run away, they don't fight, they don't shout. That might be a perfectly understandable and explainable reaction. So whilst you might expect them to do something different, you need to think about whether their reaction is reasonable and explainable. How did the parties behave immediately in the aftermath of the alleged incident, immediately afterwards? Was there any sign that the complainant was distressed? And did anyone else witness them distressed after the incident? Did either party speak to anyone immediately afterwards? If so, was any reference made in any way, perhaps direct or indirect, to what had happened? How did the parties interact in the hours and days and weeks after the event? Were there any signs of changes in their behaviour, their demeanour, in their communication with each other or their relationship with one another? And I want to stress here the importance of looking at the wider circumstances around the incident itself. And this was really emphasised in the Sellers case, where the British Council was criticised for taking too narrow a view and focusing solely on the interaction itself and not the wider circumstances. A few other things to think about. You might want to think about the extent to which recollections might have been affected by various factors, such as the passage of time or possibly alcohol consumption where something took place outside of work. To what extent could those factors have impacted on the trustworthiness of someone's account of events? Is there any evidence of an ulterior motive for raising a complaint, which might indicate that it's not genuine? But beware of placing too much emphasis on that. And remember that the absence of an ulterior motive doesn't mean there isn't one. Don't place an onus on the respondent to have to come up with an ulterior motive. You can ask them about it, whether they have any thoughts on that, but it's your job as an investigator to explore that. And is there any evidence of similar past behaviour on the part of the respondent or similar types of complaints being made about them in the past? So we touched on this earlier on. Has the respondent been found to have done anything like this in the past before? Have any other interviewees given accounts of similar types of behaviour? And has the alleged victim raised concerns about the respondent in the past? Perhaps not formally, perhaps just raising concerns with colleagues informally about things that the respondent has said or done. You can explore that as part of your investigation. Where there is really very little by way of evidence to corroborate either party's account, you're going to need to think carefully about whether or not you can make a reliable finding on the balance of probabilities either way. And you might not be able to. The ACAS guidance on investigations encourages investigators where they can to make findings on the balance of probabilities, where they can justifiably prefer one person's account to another and explain why. And again, in the Sellers case, British Council was criticised for deciding that they believed the complainant without any clear rationale. In that case, the complainant's account was noted in the investigation as being hazy, whilst Mr. Sellers gave a clear and consistent account and was clear and consistent in denying the allegation. Yet the inconsistencies in the complainant's account were not scrutinised or challenged, whereas minor inconsistencies in his account were. So be very wary about deciding that you believe one person's word against the other, one person's account against the other, particularly where there are any potential unexplored avenues of investigation, as was the case in Sellers. There is a clear risk that unconscious bias could creep in here. And remember, the onus is on you as the investigator to justify why you've preferred one person's account to another. So spell out that rationale really clearly in your report, because when you come to be questioning your findings in a disciplinary hearing, or you're being cross-examined in an employment tribunal hearing 2 years down the line, you'll be really grateful that you set out your rationale at the time really clearly in your investigation report. And I speak from experience when I say that. Zoe.
Absolutely echo that, Dave. Dealing with multiple allegations or multiple complaints. So it's really important to consider each on their merits and whether you can make reliable findings against them. So just thinking about whether you're able to make a finding on the balance of probabilities based on the evidence that you've obtained, both looking at each of them individually, but where multiple allegations for one complainant, are you able to make a balance of probability findings in favour of one party in respect of some allegations but not others? And how might that impact on the plausibility and the credibility of the other party? And it might well lead you to question credibility on other points. And similarly, when we're dealing with allegations from multiple parties, you need to consider similarities in the alleged behaviour and whether it appears to be a pattern in behaviour, and perhaps even where you might not be able to make findings against specific allegations. When you look at that overall picture, that might lead you to make a slightly different conclusion overall. And think about the types of things that you might want to address in those conclusions section of your report. So bringing all of those aspects together, looking at each of them individually, but then looking at them cumulatively as well, whether that's based on multiple accounts from one individual or multiple accounts from multiple individuals. Okay, so we're just about at the end, just going to do a really quick summary of key points, and then we'll try to take a few questions. So just the key points to take away from today. Read the guidance that's available. We've got links in the slides. We'll share the slides with you. It's really useful, particularly the EHRC one. Be prepared to vary your approach. Just think outside the box a little bit with these sorts of allegations, given the impact that they can have on the individuals and the seriousness of them. Think about whether police involvement, safeguarding needs to be taken into account. Looking at that wider culture context, the set of circumstances that may have impacted on either the behaviours or how the allegations have been made, or may provide you with that wider picture. And detail is so crucial, not only in terms of helping you to be able to reach some findings at the end, but also, as David said, if you do come to a tribunal in 2 years' time, if you've got that level of detail there to support you in how you reach those findings, it will pay dividends for you. Think proactively around that corroborating evidence. So just think a little bit wider than just what people present to you. Is there anything else that you might be able to ask for, you might be able to obtain? And make sure you've got that really clear rationale and objective rationale for the findings that you make. Right, okay. Just for anybody who joined a little bit later, we did say that if you have any questions, pop them in the chat. And what we're going to try to do now, I'm not sure how much time we've got left, people might need to jump off, but we'll have a look and see if we can just take a few questions.
Yeah, thanks, Zoe. I just had a quick look, actually. We have got a few there. And again, apologies, if we don't have enough time to answer all these questions, then, as we said at the beginning, do feel free to get in touch with us. We've got our contact details there, and we'd be happy to have a quick chat and run through your question in person. So don't worry if we don't get onto it now. So we've got a question here from Michelle Kinnear. Would you consider sexual harassment has occurred? Oh, sorry, it's been covered up by messages appearing. Would you consider sexual harassment has
occurred, even if the victim themselves were not upset about the situation, but that it could have set others, created an inappropriate culture in the department? Absolutely. Yeah. I think that even when an individual doesn't necessarily want to put the complaint forward themselves, if other people have experienced or witnessed something that they have concerns about, it's incumbent upon us to investigate that.
Yeah, I agree completely. I mean, in terms of that individual who the victim, let's call them, they may not want to raise that complaint. They may themselves feel that that conduct wasn't unwanted, but it may well be that other people have experienced the same conduct and they have felt that it was unwanted. I think, you know, whatever the situation there, you've got to look into what happened. You've got to investigate that, because it may simply be that the conduct is entirely inappropriate in that professional environment and that you need to take action to deal with that anyway. So I think absolutely something that should be investigated with a view to taking action to address it if it's effectively found to have occurred.
And there's a
Yeah.
few questions here around police involvement and just the delays, and we all know, and I think we've all experienced this when the police are involved, in the delays and the frustration for all parties. There's a question here from Rachel Arthur. It says, how can we support the individual whilst the police investigations occur? Because if the police told us not to start the investigations and speak to the respondent until they've gathered evidence, where do we stand?
Yeah. And I think you've got to respect that if the police have asked you not to start and not to speak to the respondent, you've got to respect that in unless there is a very good reason not to, because of that risk of prejudicing the investigation trial. But support is going to be really crucial there. So you will need to think, and you should be thinking anyway, about how can you support the complainant. I mean, the respondent. One assumes we're not speaking to them about it at that stage, but the complainant. You need to think about, I suppose, well-being, support for them, maybe counselling, just having regular meetings with them. Their line manager should probably, or someone in a management position should be brought into the loop on that, so that they can be regularly checking in with the complainant to see how things are going. The complainant will be involved, one would imagine, in that police investigation and any potential trial that may come later. And in my experience, that can be an incredibly traumatic experience for people to go through. Very, very difficult, and it can go on for a very long time, in some cases years. So I think you're going to have to think really carefully about the support you provide to the complainant in particular, but you also may need to support the respondent as well. So don't lose sight of the fact that they also will be going through a very difficult time, and you as an employer may have an obligation to think about their welfare and support them as well. Anything to add to that, Zoe?
No, I totally support all of that, and I think that it's a really, really tricky situation when things get taken out of our hands, and it's frustrating and it's difficult for everybody. But I think, all we can do is just try to put in as much support as we can for the people involved, understanding how difficult and distressing that is. We've got a few questions here that are quite lengthy. I think what we'll probably do with those, Dave, if you agree, is we'll have a look at those offline and see whether we can find some way just to provide a little summary response to them.
Absolutely,
because I'm just conscious of time. We've got one here that might be worth just having a quick look at if we've got time. So 2 people were in a sexual relationship that then ended. One made sexual harassment allegation 3 or 4 months later after an incident. This involved texting and asking for nude pictures during relationship while at work, which was normal between them and then changed. Things have been okay with them. Would you still continue to investigate, and would disciplinary action be taken?
Yeah. I think Zoe pitched it as well, but I think you would investigate that. You'd want to investigate it fully. I think the question would arise around whether or not that has the potential to amount to sexual harassment on the basis that at the time the conduct occurred, it doesn't appear to have been unwanted conduct. It seems to have been welcomed and consented to at the time, which would mean, on the face of it, it wouldn't amount to sexual harassment, albeit that the complainant has had a change of heart subsequently and has decided to raise an issue about this. Zoe, what do you think?
Yeah, I'd agree with that, Dave. I think it's still incumbent upon us to investigate it. What then might be the outcome might depend on the effect and the impact for the parties. And if both of those parties have sort of gone past that, then it may just be more clear boundaries around what is appropriate within the workplace, even if it is a personal relationship rather than disciplinary sanctions.
Yeah, absolutely.
Yeah.
I've just seen another question, a fairly short one, this from Stefania. in cases where CCTV footage is available, but the claimant and respondents are not aware of it, can the footage be used as part of the investigation? Yeah, I mean, interesting one there. I mean, I think in most cases where CCTV footage is being captured, people need to be made aware of it. That's my general understanding of the law around that. It may be that in this case they're not aware that there is CCTV footage of this particular incident. I don't think that would necessarily prevent you from using it. If the footage is there, I think you need to use it. You'd need to make them both aware that the footage is available, and you'd probably need to share it with them as part of the investigation so they have a chance to review it, comment on it, etc. Yeah, that would be my view on that. Zoe?
Yeah, I'd agree. And you know, as you sort of talked about earlier, David, we had that case with CCTV footage, and actually just the challenges of trying to get hold of that when it's in a bar. You know, if it's within your organisation, that's much easier. If it's something that's external, thinking about, you know, if that is available, you can try and approach them and request that information. But sometimes the best way is for one of the parties to make a subject access request, because it is footage relating to them and they are entitled to it, where we can ask and might not access it. So I think that would be one of the things that I would be exploring with any parties. You know, where were they, and ask that question: might there be CCTV footage, and can we then look at that? And then, of course, as you said, David, you know, anything that we did obtain like that, we would need to share with them and allow them to comment on it, and that would only be fair and reasonable to do.
Yeah, absolutely. And maybe just one final question. It looks like we've got one more in the list here. Are there any GDPR issues, so data protection issues, with asking for or viewing CCTV footage or social media posts where there may be others involved in the posts? I think my view on the CCTV probably mirrors what I said just now. In most cases, people should be made aware that they are being filmed via CCTV. So there should be an awareness, and hopefully you will have done your relevant stuff around putting up signs and what have you, and giving them warnings on that. So I don't see necessarily there being GDPR issues with viewing that footage. So we referred to the case just now where someone had made a data subject access request asking for that footage. So people do have a right to know and to see any footage that's been taken of them via CCTV. So I don't necessarily see obvious GDPR issues in using it for the purpose of the investigation, provided it was for that use specifically and you had a very good reason for viewing it. In terms of social media posts, yeah, I mean, there will be others involved in these posts. I think the GDPR issues may arise once you've collected the evidence and you've reviewed the evidence. If there are other people posting in those messages and they're named, they're identified, then I suppose they would have the right to know certainly what information you hold on them, the fact that you've seen those messages, whether you have to tell them specifically. Yeah, that's a complex one. It would depend on what your justification is for looking at it. But I would say if you're looking at it as for the purpose of an investigation, I would say get on and obtain the evidence and review it. But recognize that, you know, you may need to think about replying to subject access requests if people were to request information on what you hold on them, what personal data you hold, and you may need to disclose those messages to them, albeit subject to redaction. So am I missing anything there?
No, I think that's right. And I was just going to pick up on that redaction point. And I think actually having that redaction at source is quite helpful in those sorts of circumstances.
Absolutely.
So it's not you and it's not your issue. The bits that you've got relating to the people you're investigating and they're aware of it. Any other parties, you can just almost blank them out, if you like, because that bit is normally not relevant. And if it is relevant, then that's when you'd obviously need to bring those parties into it anyway, I think.
Yeah, absolutely. Yeah. Well, look, I think that's probably our last question on the list. So hopefully we've managed to cover a few there. But as I said, you know, if you have a question that's in the list that we've missed, or if you have a question that you want to put to us, we would be really, really happy to have a conversation with you and respond to your message your question as best we can. So contact us after the session. We'd be really, really happy to do that. But I think we're going to draw the session to a close there. We have overshot our hour slightly, so apologies for that. But thank you all for attending. We hope it's been a helpful and informative session for you. It's a huge subject area, this, and it's one that's incredibly important for us right now, I think, particularly in the NHS. So hopefully it's been helpful, but do follow up with us if there are any areas that we haven't covered that you'd like to talk to us more about. So thank you very much, everyone.
Thank you.
And we will.
And the slides will be shared, just because I know that there was a
Absolutely.
question on the thing there. So yeah, we'll share the slides as well.
Perfect.
Thanks
All right,
everybody's
thanks,
time.
everyone. Have a great rest of the day. Thank you.
Bye-bye.
Bye-bye.